Welcome to the Law, Your Money and You. I'm Roberta Saphire, an attorney in Sharon, Massachusetts.
And I'm Camille, Barron, a financial organizer also in Sharon, Massachusetts. And Roberta, today we're going to be learning about how some of our local attorneys, and we have one in particular who's from Massachusetts, very, very committed to advocacy. And it's so great to see someone who's in that field be in it for the right reasons and have that kind of passion.
Yeah, for the client and not the insurance company.
Right.
Yeah. So anyway, we'll just get right to it. We want to welcome you. It's Joe McManus. He's an attorney, and he does a lot here. I'm going to let him tell you a little bit about himself. Welcome, welcome, welcome.
Thank you. Thank you for having me.
Tell us a little bit about yourself.
Sure. I'm a trial lawyer professionally. I started practicing law in 2004 out in Hartford, Connecticut, at a small to medium-sized firm out there that does exclusively tort work. And tort is just a fancy legal word for personal injury actions and malpractice actions. Basically, somebody does something wrong and injures a victim, then it's a complaint and a lawsuit to recover damages for the injured person or the deceased family.
So it's either, usually in things like that, it's either a contract or a tort. So the contract accidents and injury is the difference. So you do the tort.
Yeah, I do the tort action, which are direct lawsuits against the wrongdoer. And that's what I did exclusively for that firm for 7 years out in Hartford, Connecticut. That's where the firm was based, but handled cases all over Connecticut and in some cases in Massachusetts.
How'd you end up in Connecticut when you were from Massachusetts? Just curious.
When I graduated law school, my wife decided she wanted to go to dental school. And so we kind of decided that wherever the best dental school she could get into at the time, the exact same time I was graduating law school, that's where we would go. She ended up getting into UConn Dental School, which was
good school.
Yeah, in Farmington, Connecticut, close to Hartford. And so we decided to move there. And her program, her dental school program, was 4 years. Then she decided she wanted to do a residency to be an orthodontist. That was another 3 years. And luckily she got into UConn again for the residency program there. So we were there out in the Hartford area for a total of 7 years. And then when she completed her residency, we decided we both wanted to move back to central Massachusetts, where we both grew up and both of our families still live. So that's what we did. We moved back about a little over 4 years ago now to Grafton, Massachusetts. And at that point I started my practice. I partnered up with my father, he's been practicing law for over 30 years. And I continued to do the tort stuff that I was doing. I continued to handle wrongful death, medical malpractice, and personal injury cases, both in Connecticut and in Massachusetts. Mostly it's Massachusetts, but I still do get some Connecticut work from, mostly it's bigger wrongful death or malpractice cases that Connecticut lawyers will refer to me for some reason or another. And since I've been practicing with my father, I do family law now, so divorce and custody issues and restraining orders and that type of stuff, because that's what he's been doing for his entire career. And so that's kind of the balance I have between the two practice areas right now.
Excellent. And now, when we think of tort law, of course, the thing that comes to mind is automobile accidents or medical malpractice. Is that pretty much the focus?
Yeah, those are the two big ones. Mm-hmm. Automobile accidents and medical malpractice are the two things that I really focus primarily on. And in the vehicle accidents, my kind of a subspecialty that I have is motorcycle accidents. Oh, and that's, I guess it's just because the first firm I worked for out in Connecticut had an awful lot of involvement in the motorcycle community, so we tended to get a bunch of motorcycle cases in. Which I found really interesting because I ride a motorcycle and there are issues that come up that are kind of unique to that. So,
and you have kids?
I have a young daughter. She's a year and a half.
Oh, so she's not ready to get on a motorcycle?
No, not yet. No, she sat on it with me, but that's about it.
So in your role then in this, if we use motorcycles as the example, if someone were injured or suffered a wrongful death due to a motorcycle accident?
Conceivably, that could be the case. In almost every situation, it's the other way around. it's usually the person who's on the motorcycle that ends up getting injured or God forbid, killed
From?
in an accident from somebody else who's a wrongdoer on the roadway.
Okay.
And almost
Right.
all the time, in my experience, it's just because they don't see the motorcycle. They're not paying attention. And there's a number of different ways accidents can happen. An awful lot of times it's a left turn when you're going down the roadway,
Yeah.
taking a left turn into either another road or a private driveway, and you just don't see that single headlight or the motorcycle coming in the opposite direction and pull right in front of the motorcyclist before they've got time to react. And
You know, I know in
Oh.
Arizona, the person who takes the left turn is presumed to be at fault right away. I don't know. Well, how is it in Massachusetts?
well,
and
we don't have a
Connecticut?
specific law that says if you violate it's called statutory negligence or negligence per se. If you violate one of the rules of the road, so to speak, then you're by definition negligent. But in almost every case, if that's the way the facts come out, someone took a left-hand turn in front of the oncoming motorist has the right of way, and they're going to be deemed to be negligent.
That's interesting. You know, one of the things on your website, and people would be very interested in this because we've had emails about it where people wanted to sue their doctor, whether it was for anything from the heel of the foot or taking off the wrong this or the wrong that. And you were involved. It says you were the first attorney in the nation to persuade a court to disallow the testimony of a well-known national defense expert because the expert's opinions were scientifically invalid. I'd like to hear about that because it's hard enough to bring suit against a doctor or anything. Isn't there a tribunal or something that you have to go to first?
Yeah, well, yeah, I'll tell you a little bit about that case. That case was actually a Connecticut case. Massachusetts and Connecticut work a little bit differently when it comes to medical malpractice cases. Massachusetts, you're correct. You have to go through a tribunal. So it's basically a way to weed out frivolous claims or claims that don't have merit before you would have an opportunity to get to a jury, going before a judge, a lawyer, and a medical professional and say, look, this is the basis of my claim. Usually at that point you have a report from an expert witness who is the same medical specialty as the person that you're bringing the lawsuit against. So if it's a primary care doctor, you've retained a primary care doctor as an expert, and they say, look, this is what the standard of care required. The standard of care is just what a reasonably prudent doctor under the circumstances would have done, and this is what the defendant, he or she, did wrong, and this is the injury that it caused. And if the tribunal finds that you have merit, that doesn't mean that you win the case. It just means that you're allowed to proceed with the litigation.
I got a question. Does the doctor, there's a doctor on the tribunal too? Does that have to be a doctor in the same practice,
correct.
type of practice?
Yeah, the same specialty, so they're familiar with the standard of care.
Yeah, that's hard to do.
And so in the tribunal proceedings, if you're successful, that just means that you have the right to carry on with the litigation and eventually, unless the case settles, present your case to a jury someday. So the juries would be ultimately presented with both the testimony of your expert witness and the testimony of the expert witnesses for the defense, who will presumably say, as they have in every case I've been involved with, the expert did nothing wrong, and or whatever the expert did, or I'm sorry, whatever the defendant did or didn't do had nothing to do with the injuries or the death. There
Now,
was
in
no
both
causation.
cases, whether it's automobile injury or death or malpractice, because of the nature of bodily injury, these things can go on for years. Do they first start out with an insurance claim and then it goes to court? How does that work?
Almost always. Almost always when you have a regular personal injury action, if we're talking about a motor vehicle accident, a motorcycle accident, for example, and liability is clear. So to use Roberta's example, you have a left-hand turn right in front of you. You know that the driver who made the left-hand turn in front of the cyclist or the motor vehicle is negligent. The insurance company has accepted that. Now the only thing you're really debating are the damages. How much does the insurance company for the responsible driver need to pay the victim in this case? And those types of cases, they always start off as claims, and once somebody has completed their treatment, if it's not a death case, they've completed their treatment and you know what their medical end result is, then you'll engage in negotiations about what's the appropriate way to compensate the victim. And only if that breaks down and you can't reach an agreement do you have to file a lawsuit.
I see.
In other circumstances where liability isn't clear, I'll use an example. You have a he said, she said type of situation where one motorist says, no, the light was green for me, and the other motorist says, no, the light was green for me. And so you have a question of fact. The insurance company is not going to accept liability under those circumstances, and you need to file a lawsuit in order to get to the bottom of that.
Oh, okay. Right.
In the context of a medical malpractice case, it's very, very rare, in my experience, that you're able to settle a medical malpractice case without a lawsuit. It used to be that in any medical malpractice case that you would have, if you found that there was merit and you had an expert testimony backing you up, you would just kind of put it in suit as soon as you possibly can, because, like you said, it takes a long time for the court system to play out, and you want to start that clock ticking earlier rather than later. We actually have a new law here in Massachusetts that just went into effect pretty recently that requires in a malpractice action, in most circumstances, that you're not allowed to do that. They provide for what's called a cooling down period. And the purpose of that law, the public policy, is to try to facilitate open communications between the victims of malpractice and the healthcare providers, and facilitate apologies if somebody did something wrong, and try to see if you can work out a settlement without people spending all the time and money and resources on a lawsuit. So that what that new law requires is that there's 6 months, I think it's 182 days, the law says, that you're not allowed to in which you're not allowed to bring suit unless you're going right up against the statute of limitations. Statute of limitations is the time period that bars you from bringing a claim.
What is the statute?
Statute of limitations is 3 years in Massachusetts. So if you're within 6 months of that statute of limitations, you're still permitted to file suit. If you're out beyond that 6 months, then what you have to do is you have to send a letter to the responsible party, and that letter has to be very detailed and say, look, this is what you did wrong. This is what the standard of care required. This is the errors or omissions that happened here, and this is what injury it caused. And that's usually, it's got to be backed up by your expert opinion. So at that point, you'd attach your letter from your expert that says, look, this is what happened. And then under that law, you have to give the healthcare provider the access to all the medical records within a certain time period. I want to say it's
When you say healthcare provider, do you mean the malpractice provider, or
no? I mean
providers?
the doctor of the hospital.
Oh, the doctor.
Yeah.
Oh.
So you put them on notice, and typically what happens is they'll put their insurance carrier, their malpractice insurance carrier, on notice, who will then hire an attorney to respond to that. And then under that new law, the healthcare provider, meaning the doctor of the hospital, has to give you a response within a certain time period, saying, no, this is what we did. This is how it complied with the standard of care. This is how it did not. And the whole purpose of that is it's going to hopefully facilitate a frank discussion between the parties, and you can kind of acknowledge mistakes and settle some of these cases without the unnecessary expense.
How expensive is it to bring a lawsuit like that? That would be the Superior Court too. It's not a small claims thing or a district court.
They can be incredibly expensive.
I mean, just to file it.
Yeah, and the filing fee is a drop of sand in the bucket. That's a few $100s in the Superior Court. These cases become incredibly expensive because of the expenses associated with the expert testimony, and you have to hire experts in these cases, sometimes multiple experts to testify about the standard of care, testify about causation. If it's a wrongful death case, you need to have an expert to testify about the economic losses to the family, to the estate.
Do you have where the doctors or whatever it is don't want to testify against one of their brethren?
Yeah, that has been my experience for a while, is that depending on the size of the communities, the medical communities, it might be pretty difficult to get somebody who's in the same specialty to testify against somebody who's in the same specialty if they're going to run into each other. So if you're talking about a smaller state like Connecticut or Massachusetts, and you have a specialty, say a pediatric surgeon, for example, there's only so many of them in the state, and it's probably going to be difficult or impossible to get somebody who's got the same board certification in that state to testify against somebody they might see at a professional association.
Sure.
Or that
Can you
they
get
might
somebody
know.
from another state to come in? And
Yeah,
testify?
in most
Mhm.
cases you do, and that's
You
been
probably
in almost
have to.
in almost every case I've handled. That's you have to go outside of the state to somebody who doesn't know the defendant. I do have a case pending right now in Connecticut where both of my experts are other experts in Connecticut. I think the reason why the standard of care expert is not hesitant to testify in that case is because it's a primary care physician, it's a family medicine doctor, and there are just so many of them in the state. He's in a different part of the state. They're unlikely to run into each other.
Boy.
Wow. Now, Massachusetts was one of the first states that had what we call no-fault insurance, personal injury protection. That adds yet another layer of complexity when you have
Yeah.
a damage, a personal injury, or death suit. Can you explain to our viewers how that fits
Oh,
into
yeah,
everything?
no fault.
Yeah, I'd love to. That's one of the things that I find in my practice the general public just doesn't know anything about, and they really ought to, is kind of the insurance coverage issues in an automobile case. Personal injury protection coverage is like you said, a modified no-fault situation that we have here in Massachusetts. And basically when our legislature enacted the PIP statute, PIP personal injury protection, they kind of did a balancing act where they said, look, we're going to say that insurance companies are required to pay, regardless of fault, damages for their own insured up to a certain amount in a car accident. And in exchange for that, what we're going to do is we're going to prohibit people who are injured in a car accident from bringing a claim against the responsible party unless their damages exceed a certain limit. So the real limit to that is $2,000 in medical expenses. The way the statute's written, unless your medical expenses from a car accident exceed $2,000, or you have some other real serious injury, a loss of a body part or something like that.
That's what it was 30 years ago when they first put it out.
I was just going to say, didn't they increase it?
2000. They
No,
never
it's still
increased it?
2,000, and yeah, and in my experience, that 2,000 is really the limit, because if you have a serious injury, a loss of a body part or something like that, you're going to have $2,000 in medical
Yeah,
expenses.
2000 is
Nothing
nothing
today.
today.
Yeah, and
Yeah.
so the way it works is, regardless of fault, even if you're in a single car accident, you drive off the road and hit a telephone pole, your own insurance company is responsible to pay $2,000, the first $2,000 of your medical expenses, if you have private health care insurance. If you have private health care insurance, you're then required to submit your your medical bills to your private health insurance after the $2,000, but your PIP insurance still pays the co-insurances and the deductibles and whatnot, co-pays, up until $8,000. $8,000 is the cutoff. That's the most that any insurance company under PIP has to
Right.
pay for your damages, and included in that $8,000 is the medical expenses and also lost wages. If you're out of work, they pay 75% of your average weekly wages for going back, calculated from the year before that. They also conceivably could pay other damages, like, for example, household services. If you can't plow your driveway and you need to hire a snow plow or landscaping or something like that because of damage, they could pay that. I've never seen that happen, but I know that's in the law. Theoretically, they could be required to pay that.
I want to go back to this first thing, this suffocation of a woman by medical personnel, where you were the first in the country. I want to hear about that.
Sure,
if it's
yeah,
okay.
I didn't get to that for whatever reason. Yeah, that was a fascinating case. It was a case where a rather large woman, clinically obese woman, was in a bad place at her home, and a call was made to local EMTs to indicate that she might harm herself. The EMTs showed up at her home. She was uncooperative and kind of combative with them. At one point, she took an action that they interpreted as maybe she could be harming herself. I think she reached for a bottle of hair gel and looked like she was going to consume it for a second. So the EMT said, geez, we better bring this lady into the hospital to get her checked out. She came into the hospital, and she obviously didn't want to be there. She didn't want to be taken out of her home in the first place. And so she was combative with the physician there, the emergency medicine doctor, and combative with the staff, the nurses. And so the ER doc did something that he really ought to have known you can't do to an obese, intoxicated person and he ordered that she be tied down face first, so she's in the prone position on her stomach. It had been well known in both the medical and law enforcement communities for a time before that you can't do that. When somebody's big, you can't have them on their stomach because it inhibits their ability to breathe, especially if they're intoxicated or they have any other problems going on with medication. It makes it difficult for them to breathe, and they end up suffocating to death. They call that the phenomenon positional asphyxia. Because of the position that the person's in, they can't move their intercostal muscles that are responsible for respiration, breathe in and out, and you end up dying.
Fascinating.
So that's what happened in this case. Not only did this ER doctor, who I think to spite the patient because she had spat at him and said some insulting remarks to him, ordered that she be held down in the prone position. The nursing staff then held their arms over the gurney where she was held down, which prevented her body from going up and down because she was flapping around on the gurney. They testified it was because she was going to tip it over, but it was obviously because she couldn't breathe.
Oh, boy.
There was some of these cases you don't know how the defendants are going to defend them, but they always come up with some sort of theory. And in that particular case, there was an expert who had testified numerous times in positional asphyxia cases that on behalf of the defense. And he was a doctor that came in and said, in these cases, the fact that somebody was held down, face down in the prone position, prevented from moving up and down, that's not what killed them. Something else killed them. It was a coincidence that they died, essentially. And during the discovery, it came out that the way this guy came up with his research is he was actually hired by a municipality. I believe, if I'm remembering correctly, it was the city of San Diego in California, who, when some of their police officers had done this, held a fat person down and prevented them from breathing, they commissioned this guy to do a study to kind of disprove that that's what killed the person. So what this gentleman did is he took, rather than obese people, rather than intoxicated people, he took young, healthy men in their 20s, strapping young guys, and he put them down on their stomachs and he put weights on their back, and then he measured their respirations. And he concluded, since it didn't affect these healthy young guys' ability to breathe in this position, that what happened to these people in these cases had nothing to do with the errors that the police personnel or the medical staff had done. And he had testified in a number of cases nationwide and got these people off, both law enforcement people and medical providers who had done this. And the defense disclosed him in the case we had pending in Connecticut, and he was prepared to testify the same thing, that the fact that this lady was held down on her stomach is not what contributed to her demise. And luckily we were able to convince the judge that the research that he had done was completely inapplicable to the case, because he did it on healthy young men rather than the people that all the studies in the literature said you can't do this for. And so he was precluded from testifying, and we were successful in
Bravo.
You probably had to do quite a bit of research to find that.
Yeah, we did. That was.
I bet every case involves research.
Yeah,
of some
it
sort.
did. That one was particularly rewarding, because even long after that case was over, I get calls from attorneys all over the nation about that, because they still run into this doctor who still tries to testify in the same thing on behalf of defendants in these positional asphyxia cases. So they contact me to get some advice on what I did to preclude this guy from testifying. And that's rewarding for me, because not only was I able to help the family in that case, and to the extent that I can help additional plaintiffs who've lost a loved one from being taken advantage of, again, by the defense lawyers. That's
before we go into it, and the time just flew by, and I think the original topic you were going to talk about we didn't get to, so you'll have to come back.
Sure.
But what happened to the ER doctor?
He was found liable. The jury,
was he suspended, or what?
Well,
what did they do to him?
There are two different things that go on potentially when you have a medical malpractice case. On the one hand, you have the civil liability side. And the civil liability side is just a system to recover monetary damages for the family or for the injured person. So that's all that we did in the civil case. You can concurrently or at a different time also involve the state departments of public health. They're the ones with the power to suspend license, to revoke license, to fine doctors and hospitals and institutions. I can't remember off the top of my head if there was an investigation from the DPH in that case. I think there was. I can't remember what the outcome was.
He must have looked at it and said, "You've got to be kidding." Oh, see, you've got to be kidding. We have a "You've got to be kidding" bag. See there? YGTB. And in it, we have things that people send us. And this would be an interesting topic, too, is these weird things. You know, we've been doing a financial literacy campaign. And part of it, somebody said, well, why don't you talk about pets? You know, people spend a lot of money on pets, and there are pets that don't cost much money. Like it said people have bugs as pets. I don't know why. But, but we,
the pet rock from the 70s.
Oh, yeah, the pet rock. Yeah, that was an inexpensive gift, the pet
Didn't
rock.
have to feed it much either.
Yeah. but they say, hey, Johnny hit me. What do you mean? I didn't hit him. I gave him my pet rock.
I just threw it at him, that's all.
Yeah, that's right. But we had, remember with the chickens, we brought out they were having chickens as pet, and there was a company that had 9 types of diapers there, and if you look it up, you'll see that it's one of the biggest pet things. But here's another one, pigs now, and they say they're the 5th smartest animal. So, you know, to have a pet pig. But I don't know how you would train them.
I saw something on Facebook this morning, just
So you've got to be
coincidentally,
kidding.
You've got to be
it had a
kidding me.
little video of 2 little pigs, and the person who posted it said, I decided I want a pig as a pet. And you could see the hand. The pig was probably no bigger than the person's hand. They were so cute, really cute pigs.
The little pigs.
So
well,
now,
that's
This is it. This
yeah, there's
confirms
now
it.
pigs. Somebody will come out with 9 different colors of pig diapers. And then hey, we want to thank you so much. You are truly brilliant, and this is wonderful for our viewers. I've even learned some things I didn't know before.
Yeah, it's always something new, and we most admire your integrity and your willingness to really go out there and stand up for what's right and in the interest of the law and the interest of your client.
Well, thank you very much for having me. It
Yeah,
was really
and
my
I think
pleasure.
it's nice that you practice with your father too. He must be very proud.
Yes,
Nice.
he is. We get along very well. I'm proud of him as well.
Yeah, bravo.
That's great.
Double bravo.
Well, thanks again, and to our viewers, if you have any questions, send us an email. And be sure to let us know if there's any topics that you'd like to have us cover on this show. Because remember, this is your show. The law, your money,
And you.